Chair Freiberg can go to his next bill, which I believe is the last bill on our agenda.
Yeah, so, Mr. Chair, I will move House File 1378 be referred to the General Register.
Okay, the author has moved. Did you want to move the DE5 to get it in the form of which?
Yes, I will move the DE5 amendment. Now I can provide the description I've been waiting for so long to give. So this, again, this includes provisions that Chair Quam and I worked together over the last week to include good provisions from both sides of the aisle. So specifically, it includes House File 993, Representative Gordon's bill dealing with publication of temporary polling locations, House File 1840, Vice Chair Altendorf's bill creating a standard for determining the residence of an individual subject to a civil commitment order, Vice Chair Lee's bill dealing with polling place closure and change notice until an occurrence of a presidential election or redistricting, Representative Tabke's bill dealing with absentee voting provisions, Chair Quam, it has your provision setting filing periods for special elections. The vehicle bill, House File 1378, contains a few provisions related to the timeline for filing statements of economic interest. And then both Chair Quam and myself, we had two bills. House File 1800 was yours, Chair Quam. House File 2073 was mine. They both contained multiple provisions related to the administration of elections. We took kind of the best provisions out of both bills, good provisions anyway, out of both bills, and I won't summarize them all here, but it includes a lot of them. And I think there should be a summary in your packet. So that's the DE5 amendment, Mr. Chair.
Any questions from members? Seeing none, all in favor of adopting the DE5, say aye.
Aye.
Opposed, nay. The DE5 is adopted. I notice there are two testifiers that are signed up. One of them is on Zoom. And if you want to approach, we'll have Mr. Stolberg testify first on Zoom.
Good afternoon, Mr. Chair, members of the committee. My name is Michael Stolberger. I'm Director of Property and Environmental Resources for Blue Earth County, home to about 40,000 registered voters. Thank you for the opportunity to testify remote today. I'm actually at an elections administrator training and meeting, so it's quite timely to talk about some elections policy. And in House File 1378, we see a lot of really good elections policy from an elections administrator perspective. I'm representing the Minnesota Association of County Officers. That's all 87 counties, auditors, treasurers, recorders, finance officers, and it also includes our elections administrators. Some of the good policy that we're seeing in this bill that we want to draw your attention to specifically is the removal of the permanent absentee ballot application request from the election day registration applications. This will help streamline some of our election day activities, and this was a measure that our association strongly supports. We are also very pleased to see the inclusion of the absentee ballot application deadlines. That is also a provision that the Minnesota Association of County Officers brought forward along with the Association of Minnesota Counties, and imposing a 7-day deadline for that application process in most cases other than in-person drop-offs will help with the excessive workload that occurs right before the elections, but more importantly, it will help us achieve better service to our voters by making sure that they understand their options to vote, to make sure that they can cast a ballot and have it be counted in the election. We're also very pleased to see the ballot corrections or the errors and omissions provisions that were provided in this bill. Creating a ballot that is accurate and prompt is one of our highest priorities, and having the ability to correct some technical changes automatically and to correct other changes in agreement with the parties involved without a court or judicial setting will help make that process more efficient. There are other provisions that we are pleased to see in the bill, but we do want to have some qualifications or some comments associated with them. And the first one would include the provision that allows for cities that have been delegated the absentee ballot process to restrict that to 18 days or the entire 46 days. While that provision in itself is good, and we can support that from a local governance perspective, we do have some concerns with making sure that both parties understand expectations, especially the provision that allows a city to unilaterally opt out of absentee balloting without really having the discussion with the county administrator of the elections. We also are pleased to see the chain of custody plans and the provisions that are built around that to have some consistency statewide. However, we do have some concern about how quickly the first plan needs to be adopted by counties and/or cities, and then how it would be reviewed subsequently within the next half a year. We'd like to see a potential extension on that first plan so it's more timely and tied to elections in 2026. Another provision, the last provision we'd like to just add some comment on that we still think is a good policy addition to this bill is the candidate filing period. Adjusting that late candidate filing period, so for most of our cities, our school boards, our townships, any of those offices that don't have a primary election, that period has been shifted back, which will allow more time for ballot design, and it also removes it out of conflict with the statewide primary election. All of those changes are supported. However, in my read of the bill, it looks like that change is only being applied to cities, and we would like to see that same change also apply to townships and school districts. The last two provisions I'll bring to your attention are provisions that our association has more significant concern with. While the policies in and of themselves make sense, we think there might need to be a little bit of modification to the language. For example, the college student housing list. That is now under this bill's being proposed to be allowed for all 18 days of early voting. That is a good change. It will allow us to more efficiently and effectively serve those college students that are registering to vote at their college addresses. However, that list is only provided to us 20 days before the election to be used 18 days before the election under this proposal. And those 2 days is probably not enough time for us to review the list, get it associated with the correct precincts, and then actually have it in a usable fashion. So we'd like to extend the period and get that list provided to us sooner. The last provision that we'll bring some attention to, the Secretary of State's office, Ms. Freeman, may have more comment on, but it is the provision that requires additional data to be associated with absentee ballot applications in our statewide voter system. I'm talking about the fields as in the date that the ballot was signed, the ballot application was signed, the date that that application was processed in our system. That information can be provided. We do a lot of data entry with absentee ballot applications. However, I'm not sure if the statewide system can accommodate that yet or can accommodate it by the time expected. Again, maybe Ms. Freeman can address that. In summary, thank you very much, Chair Quam, Chair Freiberg, for your work on this bill. It does bring in a lot of provisions that the elections administrators across the state will support and will see as ways to improve the efficiency in our service to voters. They're technical changes, they're administrative items, and they're changes that are much needed and much appreciated. Again, thank you for your time. I'll remain on the Zoom call for any questions that may come from the committee. Thank you.
And thank you. And Ms. Freeman, if you would introduce yourself and give your testimony. Thank you.
Thank you, Chair Quam and Chair Freiberg, for this bill. My name is Nicole Freeman. I work for the Office of the Secretary of State. I'm here today to testify and provide feedback on House File 1378. I really appreciate the work of the committee as well as in working with us as well as local election administrators to bring this bill forward here today. I believe this bill continues to support the balance of access for voters with the needs for election security, as well as making improvements to help election administrators do their jobs, which they do very well. As Mr. Stolberger mentioned, it does make a number of technical adjustments, and we're always happy to do that technical cleanup so statute's more uniform and up to date. A few of the key policies that we support in the bill are the removal of the permanent absentee application box from the voter registration application. It allows, and then the bill also allows permissively the office to add it to the absentee ballot application instead. I think that's our intent, and if there is an opportunity to change that may to a must, we prefer it was required on some form and can continue to discuss that. We also want to thank you for section number 12, which adds clarifying steps that ballot boards need to take when they're opening signature envelopes and ballot envelopes. The section makes it clear also that ballot envelopes need to be retained, and I think sets a really clear statewide process. Section 23 formalizes the chain of custody planning that county and municipal election administrators already carry out. It empowers our office to offer guidance and also promotes those discussions between local election officials and their county election officials as they update the plans ahead of each statewide election. Finally, we appreciate the inclusion of the errors and omissions out-of-court remedy. We think this will really improve the process for election officials, as well as cut down on, allow county attorneys to spend their time on other matters, and also judges in some of our particularly rural district courts where their time is strapped to. And additionally, it ensures voters can receive a correct ballot even sooner. We hope to continue conversations and hope that the committee would consider putting back in the subpoint that incentivized a candidate to come to an agreement or potentially face a penalty of paying court fees. As I noted last week when the admin bill was heard, I think that was last week. My weeks are a little blurring together, but those fees could only be required to be paid in a limited situation where the losing party, the judge found that a losing party's argument was not reasonable, and additionally, that it would not cause an undue financial burden to that individual. So we really feel like this incentive is important, and without it, that one candidate who's trying to use the error maybe unfairly to their advantage could cause unnecessary delay in getting those ballots reprinted and back out to voters. We have some, we share some of the feedback that Mako shared around effective dates and can continue in those conversations as well. And then have a couple of things that we'd also like to continue to work on. In section 6, the office would prefer 5 days for absentee applications to be received by mail, email, or fax, that the cutoff for when they need to be in, that be 5 days instead of 7. Section 7, our office shares concerns with Mako around the allowance for a city to just opt out of administering absentee voting if they are designated to do so by a county. We worry that it could cause significant gaps in voter access for voters, and the change doesn't address the impact to those voters. So we'd like to continue those conversations with all the stakeholders and members of the committee. 2 other sections I wanted to mention, section 31 and 32. Our office prefers the flexibility for locals to use unaffiliated staff members to assist voters, either inside an absentee location or curbside. Each jurisdiction chooses how they staff those pre-election activities, and requiring them to hire 2 additional party-balanced judges could be a significant financial burden for a small county or a small city. And I'm happy to continue the conversation and take questions. Thanks so much.
Thank you. And just a clarification on that, receiving a application within, the difference between 5 and 7. There are multiple occasions, different locations in the state of where some people don't receive their mail for a week. Mm-hmm. And I believe the intent was to give sufficient time to where if there was a delay in the mail, that they would actually receive it before Election Day. So I think that's something we can have some conversations on to do it. I think every party's intent is great. We just got to see what comes out with that. And the other thing I was going to bring up is there are 2 amendments. One, I moved to A6, which was recommended by the nonpartisan staff, and it removes obsolete language, and it's more of a technical amendment. And if the author had a comment.
Yes, that is a technical amendment, I believe, and I would support it.
Any questions? Seeing none, all in favor of the A6 amendment, say aye.
Aye.
Opposed, nay. The A6 is adopted. The next one is A8. It's not straight technical, but it is something that, in the rush to do the DE, there was an inadvertent portion that was left out. And this is the part in regards of clarifying the off-reservation temporary polling. And if the author had any comments of that.
No, my understanding matches up with yours that this was inadvertently left out, so I appreciate your understanding on that and would encourage members to support this.
Any clarifying questions from members? Seeing none, all in favor of the A8 amendment, say aye.
Aye.
Opposed, nay. And the A8 is adopted. And so all of the, the technical type stuff and the DE are present. Any additional comments from the author?
I know we have a few more amendments, one of which is the A4 that was Representative Jones's bill that was offered previously. Is that, would the chair entertain a motion to me offering that one?
There was quite a bit of discussion, and we came to agreement on a large number of things. This and the other two are sort of added additional to and outside of what we agreed upon. I don't think that there would be supporting votes from half of the committee. I do know that both of us had talked about some things would be offered on the floor. And so, we can go ahead and go through the process, but I anticipate there being a tie.
Thank you. I was unclear on the status of this one in particular. And and my understanding of our conversation was that we would offer that there would be some amendments from both sides in committee. So, but rather than have a negative vote on this one, I will not offer the A4. And we can continue discussions on that one.
Yeah.
And I believe members of my committee may wish to offer the other two. So.
Representative Greenman.
Thank you, Mr. Chair, and apologize, I wasn't part of the negotiations. Appreciate all the work you all did. The A4 is, or the A3, excuse me, is language that was actually adopted by the Senate and let me just explain what it does, because I think it is making crystal clear something that our law already says, which is you can't buy or bribe or induce voters in order to register or vote a certain way. And what this language does is adds a place which I think is closing or just making clear, again, I'm not sure if it's closing a loophole, I don't think the loophole is there, but that you can't offer a chance to win something that you also couldn't just provide, right? You can't indirectly advance, pay, give, promise, lend, food, money, liquor, clothing, entertainment, or anything else of monetary value. That's already in the law. What this says is you can't additionally provide a chance to win any of those things in order to induce someone to vote or refrain from voting, have somebody register to vote, or have them sign a petition that's related to the election in the time where people are already voting. Why the urgency of doing this now, and why did I think the Senate add that bill to their election is because of the election we saw yesterday in Wisconsin, and we saw in 2024 this particular innovation, if you'd call it, of offering a lottery where you can give away $1 million in order to sign a petition that you end up getting at a very specific political rally. That happened in 2024 in Pennsylvania. We saw it yet last week and up to the election yesterday in Wisconsin. The reason I think it's important that we put this in Minnesota law is in Wisconsin, also what I heard from many voting rights lawyers and public officials is that Wisconsin, like Minnesota, prohibits offering anything of value to induce someone to vote. So again, already the law, but clearly there is some uncertainty because this practice, which moved from Pennsylvania to Wisconsin, is clearly moving west. The last thing I'll say is, as we have been talking about the issue of money in politics, and again, I think some conversations we've had on both sides of the aisle, when Elon Musk or any other billionaire can give away $1 million as a lottery, we can't do that. But for him, it's, I think it's 0.0003% of his net worth. So it's like $3 to you and I. And what this does and why this is such a problematic practice for our voters, it is people using their immense amount of wealth, in this case, the richest man in the world, but it doesn't have to be that way. There's lots of billionaires, in order to induce or cause folks to vote, to participate. We don't think that you should be able to buy, bribe, or induce somebody to participate. So this bill and this language just makes it very clear. And as I said, it's already in, the Senate added it. I wanted the opportunity for us in this committee to make a stand and really say what I think voters said last night, which is can't buy my vote. But this amendment makes clear that doesn't matter who you are, you can't buy or bribe or induce somebody with a lottery or with a direct payment when we're talking about Minnesota voters. So that's the amendment, and that's the purpose for it and the urgency with which I brought it. Thank you, Mr. Chair. And Mr. Chair, I'd like a roll call vote.
Well, thank you. I guess, Representative Greenman, I understand the debate. I am surprised that there wasn't a great deal of discussion of a long history of Soros-funded activities that were meant and aimed at changing elections. And so I think this topic would need a strong discussion. Representative Altendorf.
Thank you, Mr. Chair. For Representative Greenman, just a couple questions. You're targeting or pointing out that Elon Musk had put money into the Wisconsin election that we just saw. And so my question to Representative Greenman is, how does she feel about billionaire Soros' son, I can't think of his name right now, shown clearly in pictures with Amy Klobuchar, with Governor Walz?
Representative Greenman.
Thank you, Mr. Chair, and thank you, Representative Altendorf. And if you've heard me in any other committees where I talk a lot about this, I think that there's too much money in our politics. And I think millionaires and billionaires have too much influence on all sides of the aisle. So I have no problem saying that, unfortunately, and like we heard at the beginning of this hearing, Citizens United and a whole set of other legal decisions have made it virtually impossible to stop outside political spending. I would support overturning Citizens United. I have a bill if folks want to talk about it. There's actually bipartisan interest in it. That's not what this is about. I support that. What this is about is saying it doesn't matter what billionaire supports who. What you can't do is use your resources to induce, bribe, buy, or offer as a chance. Now, we've only seen this happen once, but I know, innovation spreads. So yeah, both sides of the aisle could use this. We could see billionaires all over use this. This is value agnostic, except for it is standing up for Minnesota voters who should be able to participate without having their vote bought, induced, bribed, or anything else. And so for me, if you want to work on getting big money and billionaires out of politics, lots of bills on that, and I'd love to continue working with you. This is one of those bills.
Representative Altendorf.
Thank you, Mr. Chair. And to Representative Greenman, in the Wisconsin election that we just saw, over 70% of the donations were coming out of the state of Wisconsin to the lady that was running for the judicial position. And it was something like 10 to 20% of the donations was coming from out of state to the Republican. Okay, that is a fact. In 2022, over $36 million, $36 million came into Minnesota from DC PACs and lobbyist groups. We don't need to think very hard to know what happened in 2022 with our elections, and that there was a trifecta that happened here in Minnesota, that the governor, the Senate, the House all went to Democrat, and that $36 million was overwhelmingly for the Democrats' elections. That's a fact. Now, it's interesting, as I have sat on this elections committee now for 3 years, that we skirt this and we put things into context that were against dark money, and yet it is we are very capable of showing that the money coming into Minnesota and to Wisconsin elections, 70 to 80% of it is coming from outside of state and is funding the Democrats. That is a fact.
People watching, this is the time to get your popcorn out. And to the author, I don't think we're going to hit the 10-minute mark on this.
I tried.
But I believe Representative Greenman may have a comment.
Thank you, Madam. Thank you, Mr. Chair, and I apologize on the 10-minute mark, both of our co-chairs. I hear what you're trying to do here, but this bill is about ensuring that it doesn't matter who the billionaires are, that they can't use their billions of dollars to buy, induce, or bribe voters. So if we agree that billionaires, millionaires, anyone who has enough money to do this shouldn't be doing that, then this is an easy yes vote. I understand you want to litigate the last couple of elections. We can have that conversation. That's not what this bill does. This isn't even a money and politics bill. This just says that you can't provide a chance to win in order to induce somebody to vote or refrain from voting in a particular way, to register to vote, or to register or be eligible to sign a petition that's materially related to the election. That's what the language of this bill does. So if you want to keep outside money, if you want to keep billionaires, whether it's inside or outside the state, from influencing directly voters, then you should vote for this bill or this amendment.
Thank you, Representative. And to both members and the audience, there were provisions to monitor donations, small donations from outside the state or the area of the election. There are a lot of details that we went through in committee that didn't make it into the agreement. So I believe Representative McDonald wants to join the energetic discussion. Representative McDonald.
Mr. Chair, I'll keep it under 10 minutes. My thoughts, Representative Greenman, is if the intention is grand, certainly to keep dark money out of politics, but in the discussion, it is, I would say, inauthentic to bring up one side and not the other, such as Mr. Soros's contributions to the parties, and of course Elon Musk's supposedly, of course his contribution to the world is unfathomable to anything Mr. Soros would ever do. That's my own 2 cents. But if you want to be sincere in this, if this was my bill, I wouldn't just side one side and make an accusation of one man. If it truly is your intention and you're sincere, which I think you are, knowing you for a number of years, then to give you credence, it would probably benefit you to include both sides of the aisle of who's contributing to the campaigns, not just one side, because then that divides us. Now, this discussion could have ended had you included the very name that Representative Eldendorf brought up in contributing to the dark money politics. So that's my advice, sage advice after 14 years being here.
And to the audience, this is a preview of the floor session when this bill comes forward. Representative Davis.
Sorry, I thought you were going to speak. Thank you, Mr. Chair. Yeah, I guess I will speak to this and the unintended consequences this could be. And good point to Representative McDonald. Yeah, it already spoiled me the way you presented it, to be honest with you. Completely spoiled me. But unintended consequences of what your amendment could do. I mean, I'm just trying to think outside the box here because we have to do that as legislators. I mean, what Musk is doing is having to do with petitions. I believe in Pennsylvania, support for the First and Second Amendment, which a judge found throughout the lawsuit, I believe. And then here in Wisconsin, a petition speaking out against activist judges, which we have a very big problem with activist judges in this country right now. So I completely support his petitions, which I know your amendment is trying to address. But also I could just see a political rally where perhaps political flags or hats or shirts are being given out. And would someone be in trouble for something like that? And they had a petition there. So I just think there could be unintended consequences with your amendment, and I will definitely not be supporting it. Thank you, Mr. Chair.
And I notice you don't have one arm behind your back, but you're holding your own with multiple people in the discussion. Representative Greenman.
Thank you, Mr. Chair. And I want to just focus us in on the language. The problem, Representative McDonald, I'm trying to stop a practice that we have actually only seen one person do. The conversation about money and politics that we're having, the dark money and politics, all of those pieces, this is a voting bill, not a money and politics bill. I have those too, and in those cases, as I said, I think that there's too much money in our politics. Billionaires, we could name all of them, and there's probably many we don't even know their names of. But the reason that I had to say Elon Musk is that he's the only person who's done this. He did it in Pennsylvania, he did it in Wisconsin. And what I'm trying to say is I believe, and I think that there's good interpretation that both in Wisconsin and here, that it is against the law. So I could have not said his name, but there's only happened once or twice now. So we're getting in front of that practice or innovation. But certainly I would not want to see George Soros or Bezos or name your billionaire do this either. And so I'm happy to list all of those names. I don't want any of them to do this, which is to use their resources to induce people to register to vote. Now, I hear you on the petition. That's why this is very narrowly tailored. It's not about signing a petition. You can do that. It is about using promises to pay, to give money, to give food, to give a chance to win in order to get someone to put their name on a petition that is related to an election during the period where people are voting. And this is obviously a loophole closer, but you can have a petition. That's a First Amendment protected right. What you can't do is use those resources you have in order to induce people to register or to politically participate. To me, this is not actually a hard bill. It's already, I think, most baked into our law, but I want to make it really clear so that if this happens, we don't spend another, hundreds of millions, hundreds of thousands of dollars litigating it, and we can just say today, we don't think that the practice of buying, bribing, inducing people to participate is a good one. People should be able to do that on their own free will, and we want to keep that out of here. So that's what this bill is. Again, I would love to have bigger, more money in politics bills. I would love to get rid of dark money in politics. This is just about bribing, advancing money, and treating people in the act of voting or registering or signing an election petition in the absentee period.
Thank you, Representative. And if to believe the Strib, a billionaire targeted me a few elections ago, Bloomberg. So I think there's probably a few that get involved. Representative Roach.
Thank you, Mr. Chair. And yeah, Representative Graveman, I wouldn't support that amendment as well, or your bill. But my question for you is obviously we have some dark money in politics, but where's your position on having presidential candidates pay for endorsements from celebrities like Beyonce or Oprah?
Representative Greenman, I do think we've opened multiple rabbit holes, but Representative Greenman.
Representative Roach, we've only worked together a little bit, and you know that I could, as everybody who's been on this committee for me a long time as a voting rights lawyer, could probably talk about all this stuff, and I don't want to keep you under the 20-minute zone. I am not aware of that. I'd love to talk to you about it. I generally don't like the idea of people using money in politics to sway voters, sway endorsements, sway anything. It's not a practice I am familiar with. It's not dealt with in this bill, but I'm happy to talk to you about it. So, yeah.
Well, I think that's a different bill, preventing candidates from using money to influence voters. But it gets down into the details, and anyone else interested in joining the Seeing none. Oh, Representative.
I don't know the answer to this question. I try to make a habit of not asking questions I don't know the answer to, but how much money do we give to nonprofits of our tax dollars to encourage voters to register to vote and that kind of thing? So I'm guessing it's a considerable amount. I could be wrong on that, but so there's an awful lot of money that goes in to politics, and whether it makes a big difference one way or another, I guess I don't know. So,
Well, Representative Gord, I believe we can try and get an idea from the Secretary of State, but it would not be in the next half hour, so we'll have to get that offline. But thank you for the question. Please take the roll.
Co-Chair Quam.
No.
Co-Chair Freiberg.
Yes.
Vice Chair Altdorf.
No.
Vice Chair Lee.
Yes.
Representative Acom.
Yes.
Representative Coulter.
Aye.
Representative Davis.
No.
Representative Gordon.
no?
Representative Greenman.
Aye.
Representative McDonald. Representative Roach.
No.
Representative Vernig.
Yes.
It is baseball season. We won't be going in extra innings. A tie causes the motion to fail, and it's 6-6 tie. Is there a Representative Coulter?
Thank you, Mr. Chair. I want to offer the A5 amendment. And this language may look familiar to folks. This is the language of House File 2284, my bill, as we amended it in committee, relating to our laws around lobbying and what is and is not, who is and is not, excuse me, a lobbyist. Just very briefly, it does basically 4 things. It adds a definition for expert witness and clarifies that they are not, the situations under which they are not lobbyists. Clarifies local staff-to-staff communication and how that is not lobbying. It spells out which local government authorities might cause someone to register as a lobbyist if they are lobbying them. And then it requires the Campaign Finance Board to produce a plain language handbook around lobbying requirements. I will be brief since we don't have the option of going 20 minutes on this one. I'm bringing this forward, frankly, because the train is leaving the station. Policy deadline obviously is Friday. The state government bill, my understanding is that there is no mention of Chapter 10A in that bill, so it would not be germane to that bill on the floor. But more importantly, this is language that we asked the Campaign Finance Board to produce. In fact, we didn't ask them, we told them to produce this. And they did, and I think they did a really good job of it. And that is a group of, a bipartisan group of experts on exactly this section of law. But more importantly, even than that, this is language that our local partners, our cities, our counties, our townships are asking for. They really desperately want clarification so that their staff can continue to do the good work that we all know that our local partners do. And that is the language that is in this bill. This is a few minor tweaks, but this is the recommendations from the Campaign Finance Board as they heard them directly from our local partners. And so, Mr. Chair, I think it is important for us to go on record so that our local partners know who is serious about taking on something that I know they care about. So I would request a roll call.
Roll call has been requested. Gee, I had 47 amendments I would have brought forward if we were going to go this route where we didn't have agreement on the details and the exact language. I anticipate there being another close vote. The author?
I'm just a bystander, Mr. Chair.
Who is that puppet master behind the curtain? It's the wizard. That's an obscure reference to a movie that I saw when I was a kid. Any further discussion? Let's take the roll then.
Co-Chair Quam.
No.
Co-Chair Freiberg.
Yes.
Vice Chair Altendorf.
No.
Vice Chair Lee.
Yes.
Representative Acomb.
Yes.
Representative Coulter.
Aye.
Representative Davis.
No.
Representative Gordon.
No?
Representative Greenman.
Aye.
Representative McDonald. No. Representative Roach. No. Representative Vernig.
Yes.
And the drum roll. And it is again a tie. And the motion fails. And, you know, forgive my bad dad humor, just trying to keep it a little bit lighter than the knockdown drag out that tune in for the floor session. Any closing comments from the author?
I appreciate your efforts to bring some levity to these proceedings, Mr. Chair. The provisions in here are good provisions that have bipartisan support, and I would encourage members to support the bill.
Well, all in favor of the bill as amended, say aye.
Aye.
Opposed, nay. And the bill passes. And so the House File 1378 as amended, it passes on to the General Registry.